Aloha, this is Professor Porter. This is the course and program Introduction to Mock Trial. This is part 3 of a 10-part series. This is how to stand out, in mock trial. As always, if you can follow the YouTube channel, follow me on Twitter, follow the hashtags, or email me directly to ask any questions. Here's the premise of this whole video. Why would I do a video, especially so early after talking about the basics of mock trial, after talking about essentially why one would even think about why one would do mock trial? Why am I talking about to standing out? Because for me, if you're going to do something, why would you not want to do it to the best of your abilities? So mock trial, like anything else, if you're going to take it on, if you're going to invest your time, there's lots of things that you could be doing with your time. If you're going to do this, why not make sure you're doing it to the best of your abilities? And with respect to mock trial, I promise you, what you invest, what you do plant now will come back tenfold. These are the skills that will help you as a professional, in school, going further, just as a person, to make sure that when you're speaking to people, you're persuasive, you're effective, you're efficient with your language. When you're asking questions, same thing. So this is one of the, it's sort of what YouTube's about, right? You're going to go to YouTube because you're trying to get better at something, because you're trying to develop in something. Well, as it relates to this whole video today, part 3, is about, let's give you some tips to stand out and do your best. We're going to talk about 5 different aspects, and it's all how you present. Okay, mock trial again is about professional presentations. You're going to learn how presentations in mock trial are like the presentations you're going to have in life as a professional. So think about these stages. This is how you're going to distinguish yourself. This is how listening to this video, doing what we talk about in this video, is going to make you different from others who are simply just going through the motions in mock trial, who are lumping through mock trial, who show up to mock trial as if they have to go there, as if it's force feeding. If you present each stage persuasively, so I just want you to think about that. There's lots of different roles, lots of different stages of trial that we talked about, from the sides of the case, from the plaintiff side, from the defense side in a criminal case, from the prosecution side or the criminal defendant side. Every part of trial that we talked about. There's jury addresses, like opening statement at the beginning, closing argument at the end, the witness examinations, which include direct examinations for the witnesses that you sponsor, cross-examination for the witnesses that you're able to engage that the other side sponsors, this batting order of jury address, witness examination, presentation, I rest, the other side goes, their witnesses, direct examination, cross-examination, culminated by some closing arguments. Throughout each stage and each drip of what you present and each sentence that comes out of your face during trial, think about presenting persuasively. That'll make you stand out. The idea of, with these witness examinations, that you are going to present sharing a stage with your witnesses. It's a unique thing. We don't often, when we think about presentations, we think about standing up and making a speech. We might be making a video like this one. We think about presenting, that the focus is on us and that we're the ones doing the presenting. It's a very unique thing to essentially say, here's the presentation. Now I'm going to look like Larry King and conduct an interview, right? It's a unique thing. So if you want to stand out, present comfortably sharing the stage with your witnesses. Present in character and in control. We'll talk about what that means. You are playing a professional. You are playing an attorney, or maybe a witness, maybe an expert witness. Whatever your character is, hold to it, adhere to it. Don't be a kid in high school. Don't be someone in college. Don't be a second-year law student. Be in the character of who you're supposed to be playing. If that's a defense attorney or a prosecutor or whoever it is, be in character, and essentially don't break character. Stay in control of that character and plan for everything that happened is exactly how you intended it. That's going to make you stand out. Present uniquely for this trial. As we've talked about before, every trial, even if you do the same fact pattern, even if you go against the same people, every trial is going to be a little bit different. It's going to be a little bit different with the words that witnesses say, with the words that you say in your jury addresses, and you have to react to what happens at this trial. You have to incorporate and listen what happens at this trial. And lastly, present as a professional. Everything we do in mock trial, we are trying to project our professionalism. We're going to overdo it in a sense. Good morning, Your Honor. May I proceed? The prosecution calls its first witness. Your Honor, may I have a moment to confer with co-counsel? Your Honor, may I resume? May I approach? May I enter the well? Very formal, very professional, and you get used to it. And then in some courts, maybe if you become a lawyer later on, some courts, some of those formalities may be peeled back, or for different proceedings, it may be less formal, and you can come back. But from the beginning in mock trial, we're learning to present as a professional. So let's go. So I want to talk about this. Present each stage persuasively. Okay. One of the things that I want you to think about with present each stage persuasively is everything that we do, everything that I organize. If I have the direct examination of the victim in a plaintiff's case, I want to craft every question, the line of questioning. So each stage of it, my question, witness's answer, every bit of it coming out is designed to do one thing, to persuade my jury to act the way I want them to act, to compel them to move the way I want them to move. And it's the same thing more obviously with argument. I wouldn't be arguing to someone, not with someone. I wouldn't be arguing to someone unless I wanted to compel them to move, unless I wanted them to go with my side. So present each stage. Think about it down to each paragraph of your opening statement or closing argument. Think about it as each block of questioning in a cross-examination or in a direct examination of your witness. Each part of it, you're looking at it, you're editing it to say, is this persuasive? Does this continue to drive to the point? And I want you to think about it. There's a good analogy with written products. And I think anyone that's been through any level of school understands, if you have to write something, you have to write an essay, you have to write a paper, you have to write a letter, whatever it is, there's different parts of it. And so let's just say for the purpose of a very simple paper that we've all done in school, there's an intro, there's a body, there's a conclusion. Just think about it. How important is that introduction to convey what that letter is going to be about and to persuade? If you're trying to sell someone something, or you're trying to convince someone of something, or you're trying to tell someone, as many lawyers do, to stop doing something, that introduction, you're going to craft those sentences carefully. You're going to craft that paragraph of an introduction carefully to convey what the whole letter is going to be about, to convey what the whole paper is about. So it's important. You're persuading, you're communicating from the beginning. You're not going to have a sloppy, thrown together introduction and then take time and focus later on and have a really good conclusion. Every part matters. When you're talking about the body, you can't just go on for pages and pages and pages about everything that's in every link that you clicked on researching. It can't be everything that was in the underlying materials that you're trying to summarize to support your point, right? There's always going to be noise. There's always going to be extra stuff. You got to be the curator. You got to be the one that's the producer to say what part matters, what part can be summarized, how can I keep it down to the bare minimum. There's a great quote that says, if I had more time, I would have written less. Just think about that. The more time we have to edit, the more time we have to revise, the more time you get to pour over something. You say, justify yourself. Why are you in here? This paragraph, this sentence. Do I need it? Does it further my mission? Does it reiterate something that needs reiterating? And it's the same thing when we get to conclusion. Another good way to think about it, if I'm writing a letter or I'm writing some kind of project or submission for school or for some other reason, it might have attachments and enclosures. This day and age, if it's an electronic letter, if it's an email, I might be including links. Everything I include, I'm not going to include an enclosure and an attachment or a link to an article that says something different than what I'm driving towards, that's going to undercut my point. This is my production. This is my submission. So the intro, body, conclusion is going to be edited to essentially say, everything has to be on point. Everything has to be lined up. I'm not going to include a link unless someone clicks it and it totally reinforces everything I'm doing. That's the way you have to think about trial. I am presenting persuasively every single thing I do. I'm not going to call a witness because, hey, they were in the fact pattern. They had a deposition in the case. They gave a statement to the police at the scene. What do they do? Do they contribute something? Do they further my theory of the case? So think about that written product analogy. How would you edit it for a letter? How would you think about it for a written product? Be as fierce in the way you edit and the way you critique why is something in there. Be efficient. Good reframe. I'll try to do this throughout the program of just reframe. This classic advice that you hear, you read it in any book, and anytime you talk about mock trial, it's a lot of don'ts. They tell you don't do this, don't do that, don't do that. And frankly, you don't know what an opening's supposed to look like, or maybe you have some idea what an opening's supposed to look like, but the idea of don't argue in an opening is a confusing topic. Could be a whole video in itself because you're basically telling me to stand up, talk to someone, talk to my jury in the beginning of my case, but don't argue. So what does that leave me? How do I do it? Well, of course, experienced lawyers and folks that have been through some type of mock trial training know that you put together the facts. You have a roadmap. You preview what your theme and your theory and how you're going to win your case is. It's a lot of forward-looking organizational stuff. But if I just take on facts and I include the facts that line up, and I say fact one and fact two and fact three that line up with the way that I'm going to argue the case, I can do it in a very persuasive way. If I cut out the noise, if I summarize that which is important, if I kind of set it up. So instead, the reframe for me is you're persuading from the get-go. You're persuading from the start. The moment you stand up in trial and the jury's in front of you in its opening statement, you are persuading. So you might not be able to argue an opening. That's true, and we'll talk about what that means later on in the course. But what you're going to do is you're going to persuade. So if you have a choice between including a sentence that doesn't really further your mission, it was just in the packet, somebody said it should be in there, justify it. Why does it have to be in there? Does it serve to persuade, even if it's just a mere fact in the case, even if it's a forecast of what a witness may say or what an exhibit may go to. So think about reframing this. You're going to persuade from the very start of trial, from the moment words come out of your face. Okay, so that was presenting every stage persuasively. Now, one of the things that's going to make you stand out as a mock trial is present sharing the stage. It is very unique. You can go to some classic people that know how to conduct an interview. And the one way to think about how do I, if I'm listening to a podcast or I'm looking on cable TV to see all these interview shows that go on, are the interviewers, right? Here's how you tell if it's a good interview. Are the interviewers asking short, clear questions that feed into a longer answer that comes from the interviewee, right? Are they asking kind of reporter type questions? Who, what, where, when, why, how, describe, explain, those type of questions. I grew up on the East Coast and I had a very traditional childhood. Why? Short question provokes a longer answer. You're curating, you're hosting a conversation. Look for these types of interviews because what you'll see is the interviewers, the ones that say less and keep it short and keep it tight and kind of foster the next question coming out instead of doing more of the talking. They're the ones that are really effective at presenting while sharing the stage with their witness. And I want you to think about that. So your role is you're running this interview. You're the facilitator, you're the producer, you're the host. The key part of this, and we'll talk about it when we talk more directly about direct examination, is you're actually trying to have this presentation, you're facilitating, you're producing, you're hosting this conversation, and you hope that the jury's focus is on the interviewee, is on the witness, and that you actually fade to the background. So there's an actual skill in I just want to ask questions. I know all the answers. This is my witness. How can I ask questions and present information instead of turning to a jury and telling them? I'm essentially saying, here's a character that's actually from the play that I was talking about. Here's someone that during this car accident was standing on the side of the street. Here's someone during this crime that actually saw things go on. But rather than me tell you, let me introduce you to them. That's your role. Facilitator, producer, host, less words, less distractions, no likes and ums and whys and repeating their answers. Who, what, where, when, why, describe type questions as short and as efficient as possible. So the information, if you think about, and we're going to talk about it again when we talk about direct examination, it's a little bit like a tennis match or a ping pong match. Question, over to the witness, answer, back to the attorney, question, over to the witness, answer. So there's a little bit of a ping pong effect. What you want is will the jury, who will inevitably start by looking like the crowd in a tennis match, watching you for the question, watching witness for the answer, watching you for the question. If they realize that the key information here is coming from your witness and that you're merely facilitating, you're merely producing, you're merely the host, the Larry King of this situation, all of a sudden, as the crowd, you're asking these clear, open-ended questions that provoke the next good answer coming from the witness. Instead of a attorney looking this way, witness looking that way, they'll start to collapse and not pay attention to the attorney, not pay attention to each question because they realize it's just feed, it's just the lure to get the witness to give the next answer, and their focus will land almost exclusively on that witness. That's when you're presenting with a witness. That's how you stand out in mock trial. Can you serve as host instead of being the center of attention? You're going to be the center of attention, as you'll find out during every jury address. You're standing up in front of them and you're presenting straight to them, akin to a speech, but it's actually an argument. It's a dynamic speech. And you're also going to be the center of attention, this gets confusing, on cross-examination. We don't expect a lot to come out of the witnesses when they're the other side's witness. We want yeses. We want short answers. We want them to agree with ours, and we're the center of attention again. But when you present with a witness, your witnesses, think direct examination, you're the host, you're the producer, you're the facilitator. That will make you stand out. The focus is on the witness and the information coming out of them.